larger interest of the advocates of this country. Thank you, sir.
Shri K. Suresh.
Sir, give me an opportunity to participate in this bill. Sir, let me begin by quoting Mahatma Gandhi ji, who himself was a lawyer and an ardent champion of justice. An unjust law is itself a species of violence. Arrest for its breach is more, so states Gandhiji. The quote means that any law must be aimed at delivering justice and vacating grievances of the oppressed, and if a law is unjust, arresting someone on the basis of the law is a form of violence. So the law has to be just to itself first. It is the context of the bill and my speech. The bill titled Advocate Amendment Bill 2023 is aiming at the insertion of new section, which is section 45A in the 5 of the Advocate Act 1961, which grants power to frame and publish list of touts to every High Court, district judge, session judge, district magistrate, and every revenue officer not being below the rank of collector of a district. Each as regards their own his own code and the courts, if any subordinate there. I have certain observation and recommendation in this regard, which are follows. As per the law, the authority is empowered to frame and publish a list of touts as provided under section 45A should be confined to only judicial authorities and not executive magistrates. If the district magistrates are given such power to frame rules, we cannot ensure transparency in finding out actual touts as defined under section 45(7)(b) of the amendment bill. Sir, similarly, the offence under the amendment bill as provided under section 45(6) may be cognizable offence and the penalty be enhanced to minimum 1 year and fine at least 10,000, or else no purpose would be served. Apart from these suggestions, I would like to ask the government, through you, sir, that who is the tout and what are the benchmarks that you will use to identify a person as a tout. It is absolutely agreed that touts are a menace to the courts and justice system. What about people who would be implicated as touts when an excessive power is given to the courts? Any innocent person could be branded as tout, and that will be a dangerous situation. Sir, the question here is, we live in a highly polarized nation, divided by hatred and intolerance and discrimination. In this scenario, if excessive powers are given to the officers of the court to determine touts, anyone could be expelled from coming to the court premises. For example, a Dalit could be branded as a tout just because he is a Dalit, and an officer belonging to the upper caste and harbors discriminatory behavior towards Dalits or other communities. Another aspect is the amendment bill does not take into account any standard procedures for fixing the modes of appeal for a person branded as a tout other than appeal. This mechanism is problematic at many levels, as the appeal system in many occasions is found to be biased, and therefore I demand that appeal committee must be representative of SC/ST community, so that communal representation is ensured. I hope the Honourable Minister will agree my suggestion. Apart from this, I would also to be add that there are many issues concerning the legal system, including the reservation for scheduled caste, scheduled tribe in appointment of judges, the higher courts, which has been long-standing demand for many decades. I would like to appreciate Honorable Minister Sri Arjun Megwal ji, who is coming this ministry. So he also always for fighting the cause of untouchable people. In this law ministry, in your period, you have to take so many mechanisms for the representation of SC, ST in the Indian judiciary. I also demanded that young advocates of SC, ST community must be given necessary stipends and financial support systems during their practice, and juniors, as they are finding it difficult to survive in the present condition. The demand for High Court, the demand for another important demand I would like to bring your notice, our long pending demand for the High Court benches. So in various states there is a demand for High Court benches. In Kerala also long pending demand to set up a High Court bench in Trivandrum. So I would like to request Honorable Ministers to consider our long pending demand. Sir, furthermore, I would like to conclude saying that the amendment aiming to identify and expose doubts must not become a tool for opposition of any individual, and justice in the fairness must be implemented. With these words, once again, I congratulate Honorable Minister Sri Arjun Megawal ji as a law minister in this country to bring this important legislation. Thank you very much.
Thank you. Shri P.P. Chaudhary ji.